So a lot of times we get people that call us that have a warrant out for their arrest, and some information that we got to know to determine where and what kind of warrant is. We got to know what kind of charge it is. And so a lot of times, if it's a felony charge, it's different than it being a misdemeanor charge.
That's right. And it depends on where in the process the felony charge is. If there's a warrant out for your arrest in let's say a city court, Pascagoula, Ocean Springs, Moss Point, you're dealing with the city court at that point, your city police department. And so a lot of people will call us and see what we can do. And the first thing we do is we'll call the city prosecutor or we'll call the investigator. And we try to immediately arrange a time for you to turn yourself in, and we try to get your bond set so that when you walk into that police station in that jail, we'll walk in with you and we'll walk out together. If there's an indictment, it's a little bit more complicated. Most of the time we got to deal with the district attorney's office.
Yeah, so a lot of times when people have an indictment, obviously a question we want to ask them is whether or not they've previously been on bond before. If they haven't been on bond before, it tells us that they've never been arrested for it before. So we're starting that case, for the most part, from the start with the client. Whereas if they've been on bond for, there's a possibility that maybe they missed court they didn't know about. Mm-hmm. So there's a whole process for us getting bench warrants lifted. And so if you got a bench warrant or you got a warrant out for your arrest, that's more work for us to have to go get that lifted. And obviously that depends on a lot of factors to get a bench warrant lifted. That's
right. And, I think if you've got a warrant out for your arrest, that's where hiring a lawyer quickly can have immediate payoffs. They're able to get you a bond that you can afford, and they're able to make sure that there's no other issues that will hold you up in jail. A lot of times we have people that show up, think it's just a misdemeanor warrant, and there's some old traffic tickets from another county that'll hold them up. Or like Cameron said, there's a bench warrant, and those are tough to get lifted. But a lot of times, we go on to show that you didn't have notice of your court date, or there was some exigent circumstance that kept you from showing up to court, and we try to get that bench warrant lifted immediately.
I think we tell people all the time that if you hire us before you bond someone out, after they've been arrested, usually for a felony crime, that we can save them our costs.
That's right.
And attorney's fees by getting the bond reduced down low enough for them to bond out, still afford the bonding company, and still afford their lawyer. And so I think a lot of people just don't understand that either.
Yeah, a lot of people think that the judge sent me this bond, this is what I got to come up with to make. And a lot of our practice is getting bonds reduced for folks that are either in jail or have warrants out for their arrest. And those are a lot of times are complicated. Sometimes we can call the prosecutor, sometimes we can show up in court, but a lot of times we have to file motions and we have to litigate those issues. And that's something that we're not scared to do.
So one thing too that I like for people to know about us is our firm, I feel, is different than other criminal defense firms. Maybe I'm biased. But I think one thing that you can agree that we do a good job of is we communicate with our clients or whoever the point of contact is if a client's in jail, to keep them, fully aware of their case, the facts of their case, what's going to happen. We routinely say in our office that we're not going to let you show up to court without knowing what's going to happen. I think that's a key for a lot of people.
Yeah, and another big thing for us is we try to always make sure you're not going to show up to court by yourself. And you would be shocked at the amount of lawyers that will not show up to court. Lawyers are busy. We've got courts at the same time in various counties, but there are lawyers that will make you show up and ask for a continuance for the judge. And that's not how we operate. If you're going to be in court, we want to be there with you. And we try to communicate effectively. If there's an update for your case, we try to tell you ASAP.
And I think that's where us having a team approach to every case is different than hiring, a law firm with one lawyer in it,
mm-hmm.
Or a law firm with no support staff, because bonding companies trust us.
Mm-hmm.
Bonding companies love when we're the lawyers because we make sure our clients are at court. We communicate with our clients and make them fully aware of what's going on, and they don't have to do much, But I do think that's something that we feel sets us apart from other lawyers.
Yeah, and having two lawyers and a good team, we're able to almost personally return every single call that comes into our office. You'll either hear from Cameron or me or Kendall, and we take notes. Everybody in our office will be able to see what we've talked about. So it's consistency. It's a good system that everybody knows what's going on, and so you could call our office at any time, and if there's an update on your case, somebody's going to know about it, not just the lawyer that you've been working with.
Right. So one thing we pride in our firm is systems, and we've spent years trying to perfect and continue to try to perfect a system where, yes, you're hiring a lawyer because you want a certain result. But to get to that result, there's a lot of communication. There's a lot of client support staff communication. And that's where a lot of breakdown happens between the time someone hires a lawyer to get that result. Is there's a lot of breakdown. A lot of times, you hire a lawyer in the front end and you don't hear a whole lot until, a week before your result. And one thing that we perfected, in my opinion, is that process to keep it steady, to keep it consistent, and to keep it open communication between us, the client, our paralegals, about what's happening in the case. And I think it's fair to say, and I think any of our clients would agree with this, that when they hire us, before they hire us, we're pretty upfront about what we think is going to happen in the case. And that's something we try to do in every single case, is not predict an outcome, but based on what's happened with our experience in handling thousands of felony cases from start to finish, we're at least able to gauge what we think may end up happening in the case and at least give a client 3 potential options.
That's right. And we tell you as soon as you walk in the door, we'll never make a promise to you that we can't keep. We're never going to promise you a certain outcome in your case, because a lot of times it's not just up to us. It's up to a judge. It's up to a jury. But we do make, the only promise we make is that we will do everything we can to fight for you and to fight for your family. Like Cameron said, we can give you an idea of what we think the possible outcomes are based on our experience and what we've had to deal with and the facts of your case. But every case is different, and we're prepared to adapt and handle your case in the way that it needs to be handled.
Right, and we can't change facts. We can't create facts. When a case comes in our door, usually the case from a factual standpoint is closed. And so we're dealing with a set of facts that we had no involvement in and that we can't change. And so we like to make that very upfront. And look, we get bad cases. We get cases where people are in bad situations. They've done something bad. Maybe they're a habitual criminal. Maybe they're a first-time offender. People joke about lawyers, about how they always say it depends. But out of all the cases that we've handled, it is rare that 2 cases are ever the exact same or even close to being the same.
That's right. Even 2 similar cases, both traffic stops, both similar amounts of drugs. One's found in a guy's pocket, one's found in the panel of a rental car. Those are way different facts. And a lot of it goes into your criminal history, how you were with the officers. And there's legal defenses to a lot of these things too. There's cases where if you get pulled over, officers take drugs out of your car and they never charge you with it. Well, there's a statute of limitations. Officers only have 2 years on most drug cases to bring your case and get you indicted. Now, if you're arrested or an affidavit signed, obviously that changes the calculus, but there are a lot of cases that we have success with getting dismissed based on the statute of limitations.
Right, and there's an exceptions to a lot of things. I think something you're great at is finding loopholes, such as statute of limitations in cases. But yeah, our drug cases, that's a great example of how every case is so much different depending on the set of facts. And I think, we're talking about DUI cases, we're talking about drug cases. Obviously, we handle a lot of violent crimes, but I still think that the fact that we've handled so many cases, such a wide variety of criminal cases that, I mean, we don't ever say this much, but really and truly, we're a full service criminal defense firm. From handling juvenile cases at the youth court, the day someone's arrested, all the way up through an appeal. We've done it all here. And I think that should be important to someone who's looking for a criminal defense lawyer.